My pleasure to introduce Donna Snyder. I didn't want her to get tired and come up and introduce herself. Donna's going to be our speaker today. Donna is the Associate General Counsel at the University of Michigan. Her primary practice has been in charitable gifts. She's eminently qualified to talk about gift agreements for perpetuity. I assume she's going to tell us how to make sure that they last and don't run into problems. Donna's role at the university, I've known her for a long time, and she's one of the few people who actually continues working in the same place for a long, long time and doing a great job of it. It's a testament to how good she is at it. She assists fundraising professionals and others at the university with legal, tax, policy, and due diligence issues of giving charitable gifts to the university. And she drafts agreements for major gifts. Donna's fingers are probably on some of these, we've all heard about some of these gigantic gifts that have happened at the University of Michigan. Her fingerprints are on most of those. She assists in all aspects of making gifts acceptable to the university, including negotiating gift agreements with donors, attorneys, assisting the university in adopting policies regarding charitable gifts and other matters relating to donating to the university. Her special expertise includes affirmative action restrictions and scholarships and gifts of non-public financial interests. Donna's our president here of the Southeast Michigan Planned Giving Roundtable. We're very happy to have her as our president. She does a great job. She also serves on the board of the Glacier Hills Foundation in Ann Arbor. I did not realize you went to law school at William & Mary. Anyway, with that, I'm sorry, that's just that's a private aside. I'm from Virginia. With that, I'd like to welcome Donna up here.
Can you hear me now?
Yes.
It's a marshmallow world in the winter. So I probably won't be looking at you all that much because the lavalier over here. So please don't take offense. I'll be staring at you guys. And also, we had a couple of little technical difficulties. We think we have them resolved, except for the remote doesn't work. So I'll be pushing the button. So that means that you all in front, I'm here, hovering over you. If you have questions during this, I'm happy to take them, but I do reserve the right to defer if I'm going to cover that harsh portion of the topic a little later. And hopefully you all looked at the PowerPoint before. No, I'm just kidding. Okay, so first of all, for current gifts, I'm taking a little bit of a poll, I guess. For current gifts, how many of your organizations have agreements pretty much regularly or use agreements? Let's just say it that way, think it broadly. For current gifts. Okay, how about for planned gifts? How many use them? Okay, great. So similarly, how many of you have had to justify using agreements for especially planned gifts? Yeah. Okay, so the beginning of mine is to justify why charities should have an agreement. Am I standing in the way of anybody? You see? Whatever. Sorry. I just have to deal with it. I have to hit that button. So, first reason is the donors get to approve the charity's explanation of your wishes. So often, verbal instructions or whatever are given to you, right? When you meet with donors, you have a nice meeting, they talk, they tell you what's going on. You go back to the office and you write it all down. So then the donor gets to look and see, this is what I really want to do. Oops, I should say, would you ping me at like 10 till 2? Thank you. And second of all, the charity then gets to accept the donor's preferences, restrictions, etc. So that gives you an opportunity to educate, and it may involve negotiation, right? And maybe sometimes a long negotiation, like years long. Right. So It could take some due diligence then to get the checks for legal, financial, tax, whatever, and it may take board approval or other approvals. I do want to say that when it finally comes down to it, it's really good if you get to use the expression, the ink on the paper. But I'm only using that as an expression because I know in our shop we've started to accept PDFs and electronic signatures from donors, and maybe you have too. And that's up to your board as to whether you want a wet signature or, you know, I guess they call it that, the ink, or something else. But in any case, it's just really important to document things, especially restrictions. So again, or moving on, all parties get to agree to the terms. That's the way to really make sure that everything works out. And for current gifts, I think charities should have standard payment terms. Not too long, because you lose the time value of money, right? In our shop, it's 5 years is our ideal, no more than 5 years, although people seem to tend to sell 5 years instead of 3 or 2. But anyway, no more than some particular time. And it's really nice to have it in cash or public traded securities so that you can easily turn it into cash, right? Because what do charities do? They spend money. We all spend money. That's what we're supposed to do. That's what we're good at. We need to spend the money. So we don't want to take things that we can't necessarily have for a while. And that's true of bequests too, right? And so, like, I put in plain giving agreements that bequests should be paid in cash or readily marketable securities. And hopefully during the normal course of administration, not, again, for too long. Maybe even, you know, within a couple of years, you could say. So exceptions then can be made on a rare basis. And exceptions might include accepting non-cash assets that require special treatment. And what I'm thinking of are like closely held business interests where there's no ready market, real estate, always the kind of real estate where the donor has tried to sell it for 3 years and can't sell it, so they want to give it to you, right? Yeah, everybody knows that one. Yep. Life insurance gifts, sometimes they, yeah, so some odd life insurance things out there, right? And of course, gifts in kind, which can be a great thing and can also be a burden, like the one gift in kind that U of M Dearborn got one time that weighed so much. It was a beautiful sculpture that weighed so much we would have had to spend buku amounts of money to build a structure just to put the thing on. So fortunately, another charitable organization that already had that structure took it instead of us. But anyway, so you need to assess when you can get the cash for these. You need to assess the costs of it. Certainly you don't want to take a gift that keeps on taking. So, you know, how much is it going to cost you before you can sell it or otherwise dispose of it? You might consider another type of way or vehicle to accept these sorts of things, like putting it in a charitable remainder trust that the donor or you know, bank or whoever is the trustee for. So it's, you know, not to the charity specifically. Or there's some companies out there, as you well may know, that will accept some unusual gifts these days. So we've used Charitable Solutions for a while. Brian Ponce's company. Fidelity, I notice, is getting on the bandwagon. They'll take, they advertise that they will take interests of financial interests that are not publicly traded, and apparently some other types of unusual assets, probably Schwab and the others, you know, everybody follows. So that's another way to sort of insulate yourselves from potential liability, and then ultimately, hopefully, the charity gets cash. So another reason that charity should have gift agreements is that all parties agree to the policies that govern the gifts as the policies exist from time to time. So that was an interesting one, I think, in a way. Some donors, you know, they might look at your policies for, well, I'm thinking of endowment right off the top of my head, how an endowment distributes, and they say, oh, well, you're distributing 5%, great, let's just put that right in the agreement. Yeah, you might not distribute 5% all the time, so you have to be careful about what you put in and, you know, make sure that it's then existing or as amended or from time to time, whatever. Also, endowment restrictions must be in writing from the donor. That's what the law says. And only a donor can perpetually restrict funds, not permanently, I should say, restrict funds. So not your board or anybody. There's a quasi-endowment sort of thing that the board can restrict funds on a semi-permanent basis, but they can spend it down to zero too if they want to. So those are sorts of things that you should consider and why charities should have written gift agreements. All right, so when do you not need a written gift agreement? When there's no restrictions, maybe totally discretionary. That can come up there. And the amount really doesn't matter. So if somebody says to you, I'm going to give you $1 million to use however you want to, no restrictions, your director can decide what to do. You know, it's nice to have that in writing, but you don't necessarily need it, right? It's up to you. Also, if they're making an addition to an existing fund, the existing fund already has its terms, right? So any additions have to be bound by the terms of the existing fund. And then annual gifts, which I'm sure you all have, just regularly deal with. So you don't need necessarily an agreement for that. All right, so how about planned gifts? When does a charity need agreement for planned gifts? Again, probably don't need to justify, but let's just talk a little bit about it. The purpose and the terms could already be in the will or the trust, right? A lot of times we see that. But in the university, we have started to recommend more often using an agreement that is referred to. So the will might say, to the Regents of the University of Michigan to be used in accordance with the most recent agreement between the university and the donor. And you still need a will, you still need to name the charity, of course, in the will or the trust or beneficiary designation, whatever estate planning document there is. So the agreement just flows from that estate planning document, right? And if there is a conflict between the estate planning document and the agreement, the presumption is that the will is going to control. So the trustee or the executor or whatever has a duty to enforce whatever's in their governing documents, right? And this is another reason to have the agreement outside, because if the estate planning document has got all the purpose language in there and everything, then that puts a burden or puts a duty on, maybe I should say it that way, puts a duty on the executor or the trustee to enforce the purpose, which could get to be a little bit of a problem in some ways, depending on what happens. Whereas if it's just to the charity, and then there's an outside agreement, the outside agreement is the agreement between the charity and the donor, is not something that the trustee or the executor has power or authority or duty to enforce. So they only have to enforce the part that it goes to the correct charity, which also can be a problem if they get your name wrong or something, but that's a different problem. Okay, so, still need a will, I already did that. Right, sorry about that, I'm slower on the PowerPoint than I am talking. Okay, so, as I said, I'm pretty much a proponent of an agreement. Oh, are you going to do the clicker? And so here's the little, this gives you what's coming, okay, so you can see, and maybe just put that in front. Go ahead. Thank you, Chris. So, I'm a proponent of having agreements separately because for a number of reasons. So that's why we're here. The charity then makes sure to accept what the donor wants to do during the donor's life. You know about it, you can say, oh yeah, we'll do that, or how about we change that up a little bit? We're not really quite sure we can do it exactly the way you said it. So you have a really good idea, as opposed to being surprised when you get the will or the trust after the donor dies and saying, oh no, we have to go to probate court and changes, or whatever the case may be. Then the donor and the charity have to sign off on it. So again, wet signatures, whatever, do whatever. So Always best to do this before the donor dies. Also, the donor is informed about the charity's policies before death and can know sort of where the charity is headed, if they are changing policies or anything like that. And if there's an endowment restriction, it's in writing and it's as clear as it possibly can be during the time that we know now, what we know now, and what we hope will be there in the future, excuse me. Okay, so you can also include contingencies and alternatives, because you have to think about things for endowment purposes hundreds of years ahead, right? And that's what endowment is, in perpetuity, whatever that means. I got it. So, yeah, contingencies, I like contingencies and alternatives when something looks like it's a restriction that is going to be there a long time. You can have, thank you, you can have one again. You can have more terms and detail in an agreement, I think, than putting in the will or the trust. I mean, you can have it all in the will or the trust, but that gets really laden, right? So a separate agreement is really nice for any more terms or detail, including some other things that I can mention later about it. And especially for beneficiary designations, because you're limited to how many characters you have, right? On a life insurance form or on retirement says, I don't know. I was going to say 140, but I guess that's Twitter. Anyway, whatever. The limitation of the number of characters it is. Sometimes you can barely get the charity's name on it, let alone, saying what the purpose is for. So a side agreement or follow-through agreement is good. And it's also useful for charitable gift annuities and bequest distributions, so on. And then, of course, donors can change an agreement with you without changing their will and trust. No offense to the private attorneys in the room, but you don't have to go back and spend more money. If the will or trust says to whatever the charity is, to wonderful charity, and that's going to stay the same, but the purpose within wonderful charity is going to change, then easy to do, right? Or easier, hopefully. Right, okay, but a caution about paying existing pledges. So I think you've probably heard this before. There are certain entities that cannot pay the binding payment obligation of individuals. So a donor, is this especially true for current gift agreements, right? You can't have donor advised funds, charitable remainder trusts, and private foundations paying on the binding payment obligation of an individual. If a CRT or a private foundation pays, that's self-dealing. If the donor advised fund pays, that's a public charity using money for private purposes. And the results could be that these organizations could be disqualified as charitable. Not good. So, like in the case of a CRT, you can still do an agreement, but you do it after, or have them signed after the CRT is signed. It could be at the same sitting, but still, there's an order to these things, so that the CRT refers to, the agreement refers to the CRT that has already been. Dennis.
If you have an individual who is very generous and also has a private foundation, can you have kind of a joint agreement that either one of us can pay?
So I'm not real wild about those. And the reason is because of the potential for accidentally having a binding payment obligation. But what I've done in the past is to have the private foundation be the donor, and in the payment provision say that the individuals may pay on this binding obligation, and it will be counted to reduce the pledge. So then it's a reverse, because individuals can pay on a binding payment obligation of a private foundation without any consequences, tax-wise or charitable-wise, but not that way. So that's what I've done before. Yeah. Sorry?
I thought there had been a little bit of, on donor advised funds, there had been a little bit of a change recently, or an exception that it can pay some kind of pledge.
Robin, do you want to please expound on that a little bit?
Sure.
What you're referring to is Treasury Notice 2017-71.
Can you be more specific?
Which was released last year, I think in November. What that Treasury Notice stated was that it was kind of the weirdest notice you ever would get. Typically, what you would do is do temporary regulations, and then they would have comment, and then they would come out with proposed regs. This was a notice that said, this is what we were thinking our regulations are going to be, that then we will then go through the process. So it was like advance notice of the proposed. Anyway. And what they said is that you can rely on them until such time as they issue final regulations. And in there, what they said is that because there's always confusion as to what is a fully enforceable legal pledge, that a nonprofit can, or a sponsoring donor advised fund company can actually make a grant out of a donor advised fund that pays down someone's pledge with certain provisos. Those provisos are is that the donor can say, I'm advising you to pay this U of M on pledge number 43962. And then what the nonprofit's supposed to do, the community foundation or whatever, is supposed to turn around and say, we can't do that, but we'll make the grant anyways. But when we make the grant, we don't say pledge 49362. We just make the grant. Then U of M has to decide whether or not they're going to credit it against your pledge or not. And the view of this is that they're empowering the nonprofit to decide this. What is not clear about all of this is the conversation I had with Treasury officials last year at Foundations on the Hill, which is, does this result in taxable income to the donor advisor? Because now what you've done is you've released a debt obligation of the donor, which is release of indebtedness, and that's a taxable event. And so they said, well, yeah, we know that's an issue. We're not going to talk about it. Well, great. So your donor advisor makes a $500,000 grant to U of M. U of M releases their pledge, and then the taxpayer, the donor advisor, gets a bill for $500,000 to release indebtedness. That's not been resolved yet. So Community Foundation, no longer speaking for them, but I'll speak for them. Community Foundation still won't be a pledge because of that.
Oh,
Because there's a unsettled area here that we're trying to work out with Treasury until then. So basically, proceed at your own risk, but I would not be a pledge.
Thank you, Robin. Jerry?
And most of the time, when you get a letter from the donor advised fund sponsor, it says that you're accepting this check and you're representing that it's not payment of an enforceable pledge. So you have trouble responding to that when you in fact credit the donor with that payment. So it's pretty hard to sign and actually accept the check because you're making that representation when you accept the check.
And to kind of build off of what Donna suggested, is don't fill out the pledge form, okay? What we would always do is we would do multi-year pledges out of the donor advised fund. The donor advised fund would make the commitment. Then when it pays off its debt, it's just making it's grant installment. Just don't have the donor fill out the card.
Right. Thank you both.
Thank you.
So having said all that complexity, my next piece of advice is about gift agreements being simple. I think they should be. They should be donor friendly, right? Not too legalistic, although they are a type of contract or a contract with reliance, so you need to have some kind of legal things in them. But it's really good to be simple.
Next law should be clear.
They should also be amendable, right? Because donors change their mind, things happen to charities that are different, so you don't want to make them too locked in stone. And charities can agree to some different things, so they can agree to let amendments be made with the donor's representatives, like children or so on, if the donor wants that. It's up to you. It's a good idea for donors to contact their attorneys when negotiating contracts for major or planned gifts, because that is part of their whole estate. And some donors don't, and I'm not sure how you all define major. In ours, it's like about $10,000 or above, although I've certainly seen agreements for $1,000. Everybody wants to get that on there. Did you have something, Beth? Okay. So working with the attorneys helps the charity too, because they can negotiate the best terms if the attorney has some ideas. So let's talk about some of the elements of gift agreement, starting out generally. And this kind of harks with what Robert just said. Identify who's going to be the real donors. So you're usually talking to, Mary and Jim donor, and they are, let's do an agreement, we've got this. And so you say, okay, Mary and Jim, I'm putting your names down. Yeah, okay. You might want to just ask, who exactly is going to be paying for this? Are you paying out of your, it's very common these days to get payments from donor advised funds. So, it's a good idea. And it will make a difference, as we just said, if the binding payment obligation is in that agreement. If it's not, it might make less of a difference, but some donor advised funds are pickier about any kind of agreement being, whether it even says, like ours do, not a binding payment obligation. They're still kind of like, individuals already made it. So you want to be able to say the purpose, right, including any restrictions or preferences. If the restrictions are too narrow, the gift might not be fully used. Bad news for you, for the donor, for the stewardship people. Yeah, right. And as I mentioned before, you don't want a gift that's going to cost you a lot to administer. You want to be sure that you can do it in the course of your full administration, or if it does going to cost, then maybe the gift is paying the cost to administer. You want to say whether it's endowed or expendable. Endowment is in perpetuity, long, long time. Expendable, by that I mean currently, being able to be spent currently, or currently meaning within a shortish range of years. So you can make, certainly you don't have to spend everything in the first month or year or whatever, but within a relatively short period of time. And you can use quasi-endowment to invest if you want to for some years, but still spend it down to zero. Donor recognition. We always put donor recognition in our agreements for a couple of reasons. Stewardship, certainly. We want to know how these people want to be, well, we want to inform them, first of all. We're a public university, so their name is going to show up on certain things because we have to report certain things. And we want to know how they want their names to show up, so we put that right in there. You're going to be Jim and Mary, you're going to be James and Mary Ann, or whatever the case may be. So we put that right in there. Also important for anonymity, right? And is anonymity, does that mean it's limited to like just outside publicity? Or do they want some kind of what we call deep anonymous, where only like 2 or 3 people know who they are? And that situation comes up sometimes when you got somebody that's donating that is really close to maybe somebody in your organization and doesn't really want them to find out about it, or in the university setting it might be that parents are donating while they have a student going to school there. I know that sounds ridiculous, they're already paying lots of tuition, but anyway, sometimes it happens. So they might do deep anonymous while the student is there in the school. So, there's different sorts of questions you might ask about how this works. Maybe probably a lot of you aren't public institutions, but the recognition thing also might be affected by the Freedom of Information Act. So you need to let certain people or organizations know that, in our case anyway, might be subject to FOIA and show up in the Detroit Free Press. Oh, I didn't say that. Okay. Naming. Naming now or after it's paid? This is always a question we have at our shop. So if you're going to name something that's, a program or a building or something that's kind of big, do you wait to get a certain amount of money? Do you, if they're doing a planned gift and the naming is coming after they, with the planned gift, do you name it now or you have to wait till they die? That doesn't seem like a very good stewardship thing to do. But those are the kind of things that you have to think about for naming, and what you're willing to risk, if you will, because naming is all we really have to offer, right? I mean, a gift is supposed to be without control or without any consideration on the part of the donor. All they get back is attaboy, and maybe their name on something. I don't know. Terry.
I don't have an opinion on this. How do you feel about like a moral clause or an ethics clause? So if the donor that she named something for commits a crime public meeting.
Does everybody hear that over here? Moral or ethics clause. Yeah, so,
Putting that in up front, so I don't.
yeah, so some organizations are starting to insert a morality clause or ethics clause in there that says, you know, if the donor does something bad, they can remove the name, or all bets are off, however they word it. I've seen a number of them, they're worded differently. And frankly, I started to see some private foundations insert a morality clause that says if the university does something bad, the private foundation can say, we don't want our name in touch with this at all. They don't take the money back necessarily, just, you know, you don't use our name anymore. So we don't use them, and the reason is because our vice president for development just feels that it's chilling, that it would have a chilling effect on the donors. And our policy on removing names is quite extensive, you know, really looking at what the donor did, comprehensively. So not just, you know, one small thing, but comprehensively. And actually, so far, we've only looked at things where they were honorary namings, not donor namings necessarily. Excuse me, honorary namings and remove the name. So donor namings we've looked at, because we do have a number of things named after Alfred Tallman, a convicted felon. But in looking at his entire life and what he did, we determined that it was a relatively small part of his legacy, so we kept the name on lots of things. Yes?
Would that have to be though in the gift agreement and not in your policies and procedures?
You could do it either way, gift agreement or policies.
Because if your gift agreement is referring to your policies, you don't
Right.
have to name it.
Right.
Okay.
Yeah, so that's what we do. We have a policy, we don't put it in the gift agreement, but some people do put it in the gift agreement, or they attach, you know, an appendix or something like that, or some universities, I should say. I'm more in tune with what other universities do. I should probably make that clear in relation to gift agreements, just because I'm in a cohort of folks that share information about that sort of thing. But and it may make a difference too on, you know, as you said, what you do in terms of research on your donors and that sort of thing. But that's a tricky one. So I just gave a 2-minute it depends kind of answer, didn't I?
And are there situations where you have a donor come forward and make an offer of a gift, and others in perhaps your shop have qualms about the donor, not because of any legal problems the donor has gotten into, but because, I don't know, they don't like activities. I encountered that once in a charity where someone disagreed with the donor who was quite well known in Ann Arbor for having, he supported companies in Central America that manufactured blue jeans and such, and the donor felt, the board member felt that he was exploiting children, using child labor to manufacture these things, and he considered it to be a charitable act, or a good thing on his part. She was saying, the board member was saying, we shouldn't take any money from this guy because of that.
Well, at a big university, as you can well imagine, we have the student rally of the week about what's. So there's, you know, probably lots of things like that that come up. But you know, sure, we've certainly had people that. Now, and I will say, you know, again, I'm talking from a big organization, so we have this really thorough research group. It's embarrassing how much stuff that they turn up on people. But on the other hand, you all know how much stuff is out there in a public way. Yes, so you may well have also done the same thing and turned up all sorts of interesting things that allow you hopefully to make a more studied opinion about whether to go forward with something. Chris?
I've actually run into that. For smaller charities operating in a small community, that becomes a giant issue, because it's not just does somebody agree, but it can blow up into all kinds of things. So you have to be really, really careful about that.
Yep. Okay, what are we up to next? Payment schedule. You got payment schedule. So again, binding payment obligation. Do you really want the the payment to be bound. You want the donors and the representatives to be bound. Knowing that, this may mean that the charity might have a legal obligation to follow through on that obligation, right? Or to enforce it if it comes to that. And again, in our area, we have determined there are certain things we're willing to bind on and most of the things not. So scholarships, not. If we don't get the money, we just don't give the scholarship. Buildings, yes, we have a binding payment obligation because we have budgetary restrictions and we're relying on, you know, that money in order to fulfill our budget. So those are a couple of examples from our area. Yes.
So when you say binding, do you mean for like naming opportunities, then it must be bound with a irrevocable instrument such as a irrevocable request or something?
Okay, so binding meaning that it's a pledge that the donors' representatives are obligated under law to pay, and yes, you may well be relying on that pledge by naming something. So that's a good example. If you name something, you might want a binding payment obligation. As opposed to something that's not binding, where it's more like what I call a commitment. It's more like a moral commitment. It says, you know, I intend to or I will give, but you know, it doesn't go into the same reliance type language that a binding payment obligation, not to get all legally on you, but there you go. That's what it's about. It's a legally binding payment obligation. Rick?
Would we call that letter of intent versus?
Yeah, you can do a letter of intent, would be not binding, right? Yeah. Kim?
We've had all of those cases that you just mentioned, but this is a naming opportunity from a donor, and it's a huge amount of money, and they are on a payment schedule. So we put their name on whatever, and they make a couple payments, and then they run off. And then what do? You can't sue them.
So if it's a binding payment obligation, then...
I don't know that it's binding. It's just a letter that we send to
Right.
them, and then a letter of intent.
So if it's
make
binding, then what
payments.
you're doing is you're relying on them to do
Yeah.
their part, and that's why you're doing your part. So if they're not doing their part, you don't have to do your part.
We
So you
just
take the name off.
We just wrote it off.
Yeah,
because,
and you took the
know,
name
there's
off,
nothing
right?
we can do. Yeah.
Yeah.
Take the name off.
Right. Yeah, that's what you can do. I mean, it's a little different if you're relying on the money to do
Right.
something with it.
Right.
Namings are sort of easy in that respect, you just
Right.
take them away, but a little harder if you've got like a professor you've hired, or you build a building or whatever. So-
Are you qualifying the binding? So I'm Joe Donna, University of Michigan. I mean, you're talking at, like, we're talking major league level, and I'm down in AA ball here. But, so are you qualifying? A grift officer comes in and says, hey, look what I have. And they want to fund X, Y, and Z building. Does someone say, it doesn't look like they can fulfill this payment? I mean, is someone qualifying it, or? Okay. So.
There's a whole raft of development people in the hierarchy that you have to go through,
So that's the kind
and
of
deans, and why
infrastructure.
am I buzzing?
That infrastructure, 99% of us will
Thank
not
you.
have. We have to.
Buzzing? I don't know. I might as well. Miriam?
So has the university ever sued on one of these agreements where,
We have not sued anybody. We just work it out.
okay,
Yeah. So we either take the name off or we do something different. I mean, we've been involved in court proceedings to get plan gifts that are where we promised a naming, but I wouldn't call it suing anybody per se, and we did settle. So that's what we do. We like to settle. Yeah, so that's actually what happens. Right. What I was going to say next was you have to consider the consequences of what would happen if you got less or you didn't get what you wanted or whatever the case may be. And in the handout in the electronic handout, which was a sample template memorandum of agreement, I gave you a gift agreement and a memorandum of agreement for plan gifts. And the memorandum has a paragraph in there that says, if you don't get enough, if the charity, us, University of Michigan, doesn't get enough, then we'll do something else with the money. We won't promise to do you know, exactly what we said, because you didn't give us enough. Okay, so last thing, element, optional but helpful, so what the motivation of the gift is. And I like these especially when it's not obvious what it is. So, you know, a lot of times you get a gift that's, you know, Mary and Jim Smith, making the Mary and Jim Smith Scholarship. But what if they make the Donna Snyder Scholarship? Huh, why would they do that? Yeah, I have no idea, but they should put it right in there, in honor of, in memory of, or whatever the case may be. You know, so that it's clear what the relationship is. Okay, what are we up to now? Boilerplate. Let's kind of zip through this. Policies, we already talked about referring to them. I like that referring rather than putting in an agreement, but definitely you want to have something that refers to, you know, how they're going to change over time, as amended or whatever. And if a donor insists on reciting your policy of something or other, then you might say, that is the current policy, which may change from time to time, or something like that, so that it's clear. Or, for example, the current policy is, you know, I'm just really big on that. Okay, modifying purpose. Always anticipate that the purpose may become less useful, unless you're going to plan to spend that money within, like, you know, 3 years or whatever. But things happen so quickly, changes happen so quickly, you really need to anticipate. So what we put in our agreement says, if changes happen, we'll consult with the donor. If the donor is not around, maybe we'll consult with donors' representatives. Children, grandchildren, I never go below grandchildren. You never want to say heirs. What is heirs? That could be hundreds of people over the years. Forget that, no heirs. Children, grandchildren, period. Or designated people, even better, name them right in there. Variance clause. So a variance clause is that the charity gets to determine what's appropriate. And the way we word it is as close as possible to the original purpose. So we're trying to get the intent of the donor out. Again, this is in our, to both of the agreements that I gave you, that language is in there. Alternatively, and I've only gotten to use this once over the 22 years I've been there, you can have an automatic sunset of restrictions that might seem a little awkward, right? So the one I did 25 years from now, the restriction comes off. I love it, it's perfect, but nobody's really that interested in it. You can agree to gift over to another charity to use for the same purpose. We rarely ever do that. I bet you're not really excited about that idea either, but you know, it is an option and some donors talk about that. And if there is no variance or gift over clauses, a charity might have to go to court on a cypre action. You may have heard that term, cypre, to determine the purpose and how to really use it, what the donor's intent was. Governing law, Michigan, of course, we're all Michigan charities. Michigan Uniform Prudent Management of Institutional Funds Act, MIFA, one of my favorite laws. It has cool stuff in there like saying, you know, a donor has to give prior consent for release of modification for different sorts of things. You can get the donor, after you've gotten to the point if the donor's still living, you got to the point where you can't really use the gift the way it was intended originally, then you can get the donor to go back and say, let's release that restriction. Let's do something different. And this includes even the endowment restriction you can release, so all good. The caveat, of course, is it has to be used for a charitable purpose. We put in our agreements, it has to be used for a charitable purpose at the University of Michigan, not someplace else. Okay, additional sorts of elements. You want to match the gift to the purpose. So especially for planned gifts, this is good to think about this. You don't want to necessarily take a planned gift for construction.
Right.
Yeah, because you need the money now, right? But there's always exceptions. So one time we did a planned gift for construction, but it was a 5-year charitable remainder trust. So by the time we got all the approvals and the architect drawings and blah, 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 it was about the time that we were getting payment on that. It was great. And the donor was happy to have this money invested and he got a little bit of income off of it for 5 years. All right, you said the word irrevocable earlier. So should the payments be irrevocable? So I consider that kind of extra in the planned giving world, but it's very common to see that in planned giving. So binding is what I go with, but sometimes we throw in the word irrevocable to just have extra protection, if you will. Caveat, I think it's appropriate, and of course donors' attorneys usually agree with me, that it's okay for the donor to change which estate planning document they are going to give the money through, right? So, you know, maybe it's a donor promises to give money, and maybe you want to say specifically where it's coming from. I wouldn't do that. I mean, you know, I've got donors that want to do a lead trust one day, and the next day it's through their charitable remainder trust, and the next day it's beneficiary designation, and blah, blah, blah. As long as we can get the money from someplace, I'm not so concerned about the source. Flexibility. Flexibility, I love flexibility. Contingencies or using preferences instead of restrictions, because preferences means that you're going to try your best to do what you are promising to do, but if you can't, you can just kind of fall back and not really do that restriction that particular year. This is really good in scholarships too, where they want, you know, the left-footed dancer from Grand Rapids who is, you know, a male. And so I'm like, oh my gosh, that's a lot. So anyway, right, you just go on. And wait a second, one back. You want to include contingencies. Thank you. Okay. You're doing a good job, Chris. What is negotiable? Almost anything. I would say most things are negotiable. Certainly the purpose, payments, maybe some things that you wouldn't even think of like while we're standing here talking, but the bottom line is it could affect what the donor gets, right? So if you say, well, okay, we can accept those as preferences, not restrictions, then that changes things a little bit. We can accept a payment that's longer than 5 years, but we're not going to name the scholarship or whatever it is you're giving, the program, for the first 3 years or 4 years until we get at least half or 3/4 or whatever the amount is. So you negotiate these things. How about what is not negotiable? Oh yeah, sorry, accept administrations. You know that. You have to be able to administer whatever you accept. What is not negotiable? Well, certainly there's some preferences and restrictions that are against the law, mostly in terms of scholarships, so I'm not sure that applies to many of you, except if you're with universities. But charity controls gift. That's the big one. You must be able to control the gift. You can't have the donor, say, wanting reports before something happens. So I'd like a status update to see what you're going to do with the program. Well, that's just a recipe for the donor to want to try and control more how the gift is being used. No, no, no. They get reports after the fact, after you've done it. Policies, Michigan law, federal law, you know, those things you really can't negotiate on. Policies you might be able to some, but certainly not the laws, right? Well, unless you have a donor who's going to go change the law, but I don't know. How many of us have that? Period.
And I'm sure you've encountered this because I know I did when I was at a public university. A donor wants to create a scholarship that benefits a particular group, often the group of which they are a member.
Oh, yeah.
And
the left-footed dancer from Grand Rapids is a male.
And
I want somebody who looks just like me.
You got it. I had a donor that was very, very adamant. She wanted to create a scholarship that benefited female students of her ethnicity. And we were a public university, like University of Michigan. I said, you know, we have restrictions, we cannot.
Well, you know, where I start when that comes up is I say to the gift officer, go to your scholarship office and ask how many people have received that are just like that could fulfill those qualifications, have received scholarships, or been admitted to the university in the last 5 years. And if it's restricted enough, you're going to get an answer like, oh, maybe that donor was the last one who was admitted. Something like that. So you can go back and say, we will never be able to use this.
Well,
we need to make it
that's
useful.
easy if you've got a very particular, rare group. But,
Yeah.
But if she wants African-American females to be the recipients, chances are we're going to have a lot of those but can we restrict the
Right.
scholarship so that it only goes to African American females?
Right, so that,
I tell her, you know, that it's difficult. So we went back and forth on it, and I said, the language that I finally came up with that she accepted was, it is the donor's absolute strong preference that candidates for the scholarship be selected from this group. And that
Which-
way, we weren't completely ruling out anybody else. And I ran it past legal, I ran it past the Office of the General Counsel, they thought it was okay, then we could.
so hopefully this was before 2007. So, because the law changed in 2000, end of 2006, 2007. And any of you, I would just say, one little digression, a little advertisement sort of thing. So any of you who are interested in really specific scholarship restrictions, a colleague and I wrote an entire 20-page paper on various scholarship restrictions, which I'm happy to send you. We did it for an attorneys group that we belong to. And it covers pretty much everything you might ever want to know in the scholarship restriction area. So you can ask me about that, but I don't want to get too far into the weeds on that one. I just want to say there are usually options, even on the not negotiable thing. Because like I said, it just depends on what the donor gets. So what are some common concerns? From the charity's point of view, that the gifts are not flexible enough, right? Yeah, we were always looking to, you know, how can we really use this money more flexibly? And even when you take it at the beginning and you think it's flexible enough, 3 years later you're going, oh, why did I do that? Or 5 years later, or 20 years later, it's, yeah. So, and also that the donor wants to be involved a lot with the gift, right? So, this one, I just hate this comes up, but I'll give you an example that has been coming up more frequently. And that's at a big place like ours, and probably at small places like yours, donors form bonds with certain people. So they want those people to be there running their programs that they're going to fund, and they want it in the agreement that the university will use its best efforts or whatever it is to keep the people there. No, that's really not, that's getting into the university's business. What we have said was, you know, we will certainly keep an eye on these people. We know they're key people to you. We'll put in the agreement who the key people are, and we'll let you know if something happens with their employment. We're not going to promise anything in relation to trying to keep them, especially in these days where it's easy for people to move around. And anyway. Don't get me started. Okay, from the donor's point of view, what are some common concerns? Well, that the charity they don't trust the charity to follow the purpose that they said, right? They think that the charity is just going to turn around and do whatever they want. This probably is related to flexibility. When we do, maybe turn around and do something a little different. But constant communication is the best thing, right? You need to be talking to the donors about what you're doing, how you're doing it, how you're spending the money, showing them. And then if things change, then hopefully they're on board with it already because they've seen some changes. And that the charity doesn't even use the donor's gift at all. I hope you don't have this in your shops, but we do have this in ours where, especially in the areas that don't get very much money, they get a gift and they're like, oh, we got a gift. Oh, we can't spend it. It's our rainy day fund. And you're like, no, you really need to spend it. The donor said, here's the purpose. You need to follow the purpose on that. So those are common concerns that I see and common frustrations. And with that, I want to now let you all talk. I want to just say, make agreements for perpetuity with your successors in mind so that you leave them good gifts. What questions do you have otherwise? Other than what's already been, Laura?
All right, it's a little crazy, but that last thing that you brought up about spending the money.
Yeah.
Like as a donor, is there a way if a donor ever says to you, you know, I know this happens at universities, blah, blah, blah. Is there a way to write something in there that they have the ability to check into if it's actually being used, and if it isn't, then they will pull it out? Or, I mean, how does a donor have more power? Because go ahead.
Well, I was going to say, we commonly put reporting requirements in there. I mean, after the fact, but annual reporting or twice a year reporting, whatever, you know, to say, okay, this is the amount of money that we've spent and how we spent it. And that's really common in the medical area, but it's getting more common in other areas too. Certainly, for programs, you invite them to the stuff that they're supporting, right? You know, if they're supporting a lecture if they're supporting some kind of event or whatever, if they're, I mean, even if it's just an ongoing program, you invite them and you say, this is what your money bought. It bought these tables or these computers or iPads or whatever the case may be. I think I'm not a stewardship person, but I see the fallout from not stewarding donors correctly, because then they get mad and they don't want to give, or they want the money back, which we don't like to do, or whatever the case may be. So it might end up in my office, and a lot of times it's a stewardship issue. And that may be the next session, talking about the stewardship. But certainly you have to keep donors informed without being so involved that they're running the show.
Right, and one thing I guess I want to say is, like, as a gift officer, you're writing the agreement and you're planning on delivering on it, but then you have a dean that makes other decisions that you have no power
Oh,
over.
you need to get the dean's sign off for sure.
Well, and they do, but then what happens if the dean says, oh, I'm not going to do that because we're going to hold on to it for a while. That's where that stuff does happen, and that's where it gets tricky, and it's not the gift officer's problem. I mean, it is their problem.
Yeah.
I mean, it's not their fault.
Absolutely.
It's not their fault. You can steward all you want, but if the dean or whoever controls the money isn't spending it,
Yeah.
you're not the boss of them. And, in smaller organizations, you may have more luck, but in larger
Well,
organizations.
even in smaller, the director might want
Oh, you're
to
right. Yeah, good
divert
point.
something, right? The
Yeah.
head person, so. And some of those organizations have gotten in trouble in a big public way for not spending money or spending money inappropriately or whatever the case may be. So, I mean, that's good. I suppose that the charities that are doing wrong are shaken out.
You mentioned earlier about your gift agreements, and you don't necessarily state the vehicle in the gift agreement, in the MOA, as to how, and can you speak a little bit more on that as to, doesn't matter, or it's nothing legal that you have to have the vehicle in there?
So, no, you don't have to have the vehicle in there, and the vast majority of our agreements are going to be cash or readily marketable securities. We do actually do specific agreements for specific types of agreements. So if you're taking a limited partnership interest, that has a transfer agreement all on its own. And so that's not something the charity does. If you're accepting real estate, there's a deed.
Right.
So, like that.
But like for a simple bequest, then you don't even put in there that it's coming via the will or the living trust or last will and testament.
The only time, or I shouldn't say only, but there are times when it might say it's likely to come through, or where the donor has set up the beneficiary designation on retirement account at Schwab or something. And so helpful information like that is really great, because then we know where it's coming from.
Right.
But typically, we don't put it in. No.
But it's nothing to matter legally if you do or don't.
Correct.
Okay, thank you.
Sir?
You make reference to minimum amounts, especially for endowments, especially when you have an estate gift. Perhaps now for the amount for an endowed scholarship might be $25,000. So the donor puts you in this estate plan for $25,000. But when the money actually comes, now the minimum is $50,000. Put that kind of language in your agreement.
So that's exactly what's in the memorandum that came to you via the distribution email from Lori. There's a paragraph that says, if this is endowment, or if you intend, actually it's written as intent, donor intends it to be endowed. If it's intended to be endowed, but it's not sufficient for the minimum required amount at that time, at the time of death, and we tag it to the time of death, not the time we receive it, because there could be quite a lag. So, then we'll do something different. We'll either save it and hold it and try and build it, or spend it all, just depending on how much we get. But yeah, we try to accommodate the minimums, because I know exactly what you're talking about. Thank you very much, everybody, for coming out today.
Donna, just as advertised, we had a big crowd here today to hear you, and they